A single Supreme Court ruling didn't just tweak a statute or knock down one regulation. It quietly rewired the way gun laws survive or collapse inside courtrooms. And that shift has already reshaped several major legal battlegrounds without most gun owners ever realizing it happened. This isn't the kind of change that screams for attention. It doesn't always come with a dramatic press conference or clear headline. Instead, it works in the background, influencing how judges think, how states react, and how quickly an ordinary person can drift from law-abiding into serious legal trouble without intending to. Before we get deep into this, let me ask you something real. How many times have you seen a headline about guns and thought, okay, that's settled, and moved on? Because what I'm about to explain is exactly why trusting a single sentence summary can get you burned. Laws didn't just change. The rules for judging those laws changed, and once you understand that, a lot of confusing outcomes suddenly start to make sense. For a long time, people assumed the biggest gun stories were things you could see clearly: permits to carry, bans on certain rifles, magazine limits, or some new federal agency rule. Those issues are big, no doubt, but the quieter, more powerful shift happened underneath all of that. The Supreme Court rewrote the method judges must use when deciding whether a gun law is constitutional. That method traces back to a case that most people know only by name and sound bites. A case involving New York and its old carry permit system. In everyday language, that case shut down a system where ordinary people had to convince government officials they deserved permission to carry a handgun in public. New York required applicants to show a special need, not just "I want to protect myself," but something extra, a reason officials personally found convincing. The court said that crossed the line. The Second Amendment protects carrying firearms in public for self-defense, and the government can't turn that into a privilege reserved for a few. But that headline barely scratches the surface. The deeper impact wasn't just about permits. It was about how courts analyze every gun law placed in front of them before this decision. Many courts followed a familiar routine. First, they asked whether the Second Amendment even applied. If the answer was yes, they moved to a second step and weighed the law against the government's stated goals, usually public safety. Judges balanced rights against policy interests and often deferred to lawmakers. The Supreme Court told them to stop doing it that way. Instead of balancing modern opinions about safety against individual rights, courts were instructed to look at the actual text of the Second Amendment and compare modern laws to historical traditions of firearm regulation. The burden shifted. Now the government must show that a contemporary restriction fits within a pattern of regulation that has roots in American history. That might sound academic, like something only constitutional scholars argue about, but it has very real consequences. If you carry a firearm, travel across state lines, buy parts, build firearms, or simply want to avoid becoming an example in someone else's lawsuit, this new framework is already reshaping outcomes in ways that look contradictory. Until you understand the logic underneath, let's walk through how this has played out. Starting with public carry, on paper, it looked like a nationwide win. States that used discretionary permit systems were suddenly under serious legal pressure. Those systems became hard to defend, and many states changed their laws quickly. People celebrated. They believed the fight was over. That's where the trap appeared. Some states didn't surrender. They adapted. Instead of blocking permits outright, they shifted focus to where carrying is allowed. They expanded lists of so-called sensitive places, areas the government claims are too delicate for firearms. Historically, that concept applied to narrow categories like schools or certain government buildings. After the Supreme Court's ruling, some states stretched the idea so far it started to resemble a carry ban in disguise. The practical effect is this: you might legally hold a permit and still risk criminal charges just by walking into the wrong place without realizing it. Think about a normal day: gas station, coffee shop, pharmacy, a quick stop at your child's school, a government service counter inside a commercial building, dinner at a restaurant. In your mind, you're compliant. You did everything required, but under expanded sensitive place rules. The problem isn't whether you're licensed. It's whether you crossed an invisible line you didn't know existed. Picture a modern shopping complex. There's a private medical office, a daycare, a small government desk, a bank, a cafe, and a restaurant, all under one roof. Would you confidently know which sections are restricted and which are not? Under the newest rules in your state, right? Now, most people wouldn't. And that uncertainty is dangerous, because criminal law doesn't care whether the layout was confusing or the signage unclear. This is why celebrating a Kerry victory without understanding the new map of restrictions can be misleading. The battlefield moved, permits became easier to get in some places, but compliance became harder to navigate. That shift alone has already caught people off guard. The next major change surprised a lot of observers who assumed the new legal test would wipe out nearly every gun restriction. It didn't. One of the most watched fights involved a federal law that temporarily prohibits firearm possession for people subject to certain domestic violence restraining orders. Many expected that law to fall once courts applied the new history-based approach. Instead, the Supreme Court upheld it. The reasoning matters more than the outcome. The court emphasized that American legal tradition has allowed the government to disarm individuals who are found, through court process, to pose a credible threat to others. The restriction wasn't permanent. It wasn't automatic. It was tied to a judicial finding and limited in duration. This ruling clarified something crucial about how the history test works. Many people believed that unless a law existed in the exact same form centuries ago, it couldn't survive. The court rejected that idea. It accepted historical analogies. Older laws that address similar risks, even if they look different, could justify modern regulations. This reveals a subtle but important shift in focus. It's not only about the object, the firearm itself, it's also about the person and the assessed risk. That doesn't mean anything labeled public safety automatically passes constitutional muster. Broad, permanent, or untethered restrictions still face serious problems. But laws that are narrow, temporary, and tied to specific findings have a stronger chance of surviving under this framework. Understanding that distinction matters. The strongest legal challenges going forward aren't driven by outrage alone. They're built on showing that a law goes too far, lasts too long, or disconnects entirely from any real historical precedent. This ruling explains why some gun laws remain intact even after the Supreme Court changed the test. It gave lower courts a way to apply the new method without invalidating everything. Now shift gears, because the next change didn't even revolve around the Second Amendment directly, and that's what makes it unsettling. A case involving bump stocks focused not on constitutional rights, but on statutory interpretation. The question wasn't whether bump stocks should be legal. The question was whether a federal agency correctly classified them as machine guns. Under existing law, the Supreme Court said the agency went too far. The statute defined a machine gun as a weapon that fires multiple rounds automatically, with a single function of the trigger. A semi-automatic firearm equipped with a bump stock didn't fit that definition as written. The court didn't praise bump stocks. It simply said agencies don't get to stretch language until lawful owners become criminals. That distinction should make every gun owner pause. The biggest threat isn't always a direct ban passed by Congress. Often, the danger lies in how terms are defined and redefined. What counts as a firearm? What counts as a receiver? What qualifies as a machine gun or a suppressor? What does readily convertible mean? These definitions can change your legal status overnight. Imagine buying something that's legal today, keeping records, following every rule. Then an agency announces a new interpretation and declares that item prohibited, destroy it, surrender it, or face charges, even if you dislike the product involved. The precedent matters. This case sent a message that criminal liability must come from clear laws, not creative reinterpretations. That principle affects far more than one accessory. At the same time, another decision showed that federal authority still has teeth. A case involving unfinished frames and firearm kits upheld regulations that treat certain parts as firearms when they're designed to be easily completed. This decision expanded the government's ability to require serial numbers and regulated sales channels for some kits. Again, this wasn't a classic Second Amendment showdown. It was about statutory authority and definitions. Builders and hobbyists felt the impact first. Many people misunderstand this area entirely. Homemade firearms aren't automatically illegal everywhere. The details matter. How complete the item is, how it's sold, and how it's marketed all play a role. The real-world risk is accidental noncompliance. People don't set out to break the law. They assume yesterday's category still applies today. In this area especially, classifications can change quickly, and those changes carry criminal consequences. Then, there's the issue that frustrates almost everyone: the Supreme Court's refusal to quickly resolve challenges to certain high-profile bans. Many expected fast answers on magazine limits and so-called assault weapon restrictions. Instead, the court declined to hear some cases. That doesn't mean approval, it means delay, and delay has consequences. When the court steps back, lower court rulings remain in effect. Those rulings influence other courts, even if they aren't binding nationwide. The result is a fractured legal landscape that lasts for years. Your rights can change dramatically the moment you cross the state line. Equipment that's ordinary in one state becomes contraband in another. A magazine in a range bag, a feature on a rifle, a carry rule tied to posted signs instead of default permission. Some states flip the rules entirely, making carry illegal unless explicitly allowed by property owners. Think about traveling with firearms the way you think about international travel. Different rules, different assumptions, different risks. A routine traffic stop can spiral quickly when property you've owned for years suddenly falls into a prohibited category. Even if charges are dropped later, the damage is real. Legal fees, time, stress, seizures, employment issues. And all of this exists while courts continue to argue, test, and reinterpret the new framework. That's why the Supreme Court's pace matters, while judges debate history and analogies. You're the one living under today's enforcement, so what do you do with this? First, stop trusting single-line summaries. Ask what kind of case it was. Constitutional, statutory, agency authority, each one affects you differently. Second, understand that the history-based test is an engine, not an endpoint. It will keep producing new outcomes as laws evolve. Third, remember that targeted, temporary restrictions tied to specific findings are treated differently than broad, permanent bans. Fourth, assume the law changes when you travel, because it does. And finally, think in terms of upgrades, not what I'm learning. Court decisions, injunctions, appeals, and enforcement shifts can all change the rules faster than most people expect. The biggest mistake gun owners make isn't malice, it's complacency, relying on old information, trusting headlines, assuming yesterday's rules still apply today. The Supreme Court didn't just change one law, it changed the playbook, and that playbook now governs who can carry, where you can carry, what counts as a firearm, what counts as an accessory, and how quickly legal ownership can turn into a legal nightmare if you're not paying attention.